The Ripple SEC case is, why it was filed, and whether or not I think it means we're going to the Supreme Court. We just got a brand new filing in the Ripple SEC case that directly relates to this case going all the way to the Supreme Court. Many attorneys, including John D. and Jeremy Hogan, have been paying close attention to this filing's progress in the Supreme Court. Because this is so interesting, we're going to analyze their arguments in detail at the end of the clip. Also, I'd like to discuss some recent developments. We're about to make a big splash in the crypto market. There are 2 major happenings coming up next week. Things you won't want to miss, so stay tuned to the very end of the film to prove to yourself that you're not as oblivious to the video's ending as I am. If you enjoy the videos here and want to see more, your subscription would be greatly appreciated. If you like this, please click the like button. Next, scroll down to hit the subscribe button. These 3 easy additions to bell notifications will assist tremendously. This feed expands, and not just in theory. Mean a lot to me, and if you ever want to buy any XRP or the Flare token, my recommended exchange is said in the video's title. So without further ado, let's get into it, and I hope you all enjoy the content. To kick things off, I'd like to discuss a brand new file that Ripple just made to the Ripple SEC lawsuit, as so many people are following the case. As both parties have already filed their respective briefs, we do not anticipate any further filings in this matter. Their last briefs for summary judgment, so the entire case is now fully briefed and before the judge. As a result, no new documents were expected, and Ripple came as a surprise earlier today and added a fresh filing to this lawsuit. It pertains to the possibility of the case being heard by the Supreme Court. To avoid getting bogged down in the details, suffice it to say that the Supreme Court's recent ruling prohibiting lawsuits based on lack of fair notice is at the heart of Ripple's filing. If they didn't have a good grasp of the implications of their actions, was incorrect, and it is now clear how this relates to the SEC's lawsuit against Ripple on the grounds that the company should have understood this from the start of the company's existence. We can clearly see from the SEC's actions, lack of clarity, an agenda to allow certain projects a free pass that their sale of XRP was a securities violation, for which the Ripple founders should be held liable and should be held to the maximum punishment. As the SEC has started making pronouncements on cryptocurrencies, it is extremely unlikely that Ripple knew XRP could be considered a security. The marketplace is completely opaque, and have only added to it by going out of their way to say that every single ICO to date has been a security while simultaneously saying that Ethereum is not a security and giving Ethereum a free pass, saying that Ethereum made a transition from a security to a non-security, and saying that this could apply to any single token out there, leading everyone to believe, hey, my token isn't a security anymore either. And we've reached decentralization, we're jacked. We don't expect to be paid, but that's fine. In any case, the SEC has been very vocal about the fact that tokens are in fact securities. What we were discussing earlier was actually Ethereum. That's interesting, but it's possible it's not true. Now, and by the way, tokens used for making payments can also be securities. There is no one to turn to for help, and nobody around here has a clue. Allowable content, no one is sure what is forbidden, and the Supreme Court just issued a ruling saying it's not okay to sue someone in this way if you haven't told the SEC what to do. Can't be targeting players with statements like, the SEC is taking advantage of the glaring lack of clarity in the market and trying to punish people, so hey, you broke the law here. That's why the Supreme Court ruled it couldn't happen, and today it seems totally ludicrous. Ripple just filed a good case, Jeremy Hogan has commented, favoring it. The Supreme Court's ruling that ordinary individuals do not need formal notice before a trial gives the fair notice defense significant weight. We're both lost and could use some direction, and be familiar with the regulations and statutes. The SEC is currently operating in a bullyish manner. They have noticed a lack of transparency in the cryptocurrency market and have issued a warning. We must clarify these issues before we are sued. Oh, great! Now we can say that the SEC should not be taking action because the Supreme Court just ruled that what they are doing is illegal. Just like a bully. I don't see the big deal here. Several people are claiming that this is the true import of the current events. So this is how Ripple finds out. The Supreme Court has agreed to hear this case. Gentlemen, you can't believe that because Ripple. I have no idea what will happen, but I believe it is crucial to realize that the fair notice defense only applies if Ripple's lawsuit is unsuccessful and XRP is found to be a security. If you come out on top, then justice becomes unnecessary. It's only fair to give Ripple a good review since he's always played by the rules. The term, straight up, is obsolete today. I tweeted an explanation in an attempt to clarify the situation. This is what I anticipate will occur. I hope this worst-case scenario for Ripple may be useful to you. Understand the significance of fair notice in the context of the current events. I believe Judge Torres has a good chance of success. The secondary market does not consider XRP a security, and so must find that it does not at this time. I believe the decision has been made for us. Specifically with regards to John Deaton. This is a huge triumph for XRP. Ripple's sales of XRP, or when they sold XRP in the past, those sales should have been filed with the SEC. She can rule at the same time. And therein lies the danger for Ripple. Market for XRP secondhand, as I'm sure we can all agree, our XRP isn't a security officer, but it's possible that Judge Torres may rule that Ripple should have registered these sales as a securities violation and that the SEC is demanding a $2 billion fine. Possibility of a stock exchange. The fair notice defense would so apply, and Judge Torres would likely agree and say, "All right, you're correct. The SEC was vague about your status. Even if I agree that you should have been registering the tokens, what you did was still improper. In light of this, we agree to accept your defense of fairness and reduce your total obligation to $100 million from $2 billion. And that's basically all there is to the fair notice. Protecting yourself merely entails limiting the damage. Influences that cause reverberations if they are unsuccessful with the SEC. It will be because they failed to register their sales when they were required to do so. In my opinion, that's not going to happen any longer. A majority of Ripple's sales may be legal if Judge Torres rules that XRP is not a security, which I believe she will. Although Ripple's case is compelling, it must be borne in mind that Ripple. This in no way suggests they anticipate taking their case to the Supreme Court. It's a precaution for the worst-case scenario. Situation, which further proves that Ripple is always one step ahead of regulators at the SEC, who are currently perusing this case. So bad, not only are we failing miserably to prove that XRP is a security, but now, even if we do achieve a little win, Ripple is still going to be able to defend themselves and nullify much of our fine, and John D. has now chimed in on this. Was something I placed high value on, and he stresses the significance of Ripple's. Winning a case against the SEC is even more likely than it is at the moment in the Supreme Court. It seems from what John Deaton is saying and what we've heard from the other lawyers that Ripple's lawsuit is doomed to fail. It bears repeating that I don't think they're going to lose this case, but even if they do, they have an even higher chance of prevailing at the Supreme Court level, because we can see right now is that the SEC is in a horrible situation. Ripple's petition today reveals that even if they lose the case now being litigated, they have a fantastic backup plan to fight the SEC at the Supreme Court level. No one knows whether or when this case will make it to the Supreme Court, but preparations are being made just in case it does. Compared to the SEC, the legal team is light years ahead. Weekly, the SEC's legal team shifts their position, and they have failed to really formulate a coherent strategy. Nevertheless, Ripple's legal staff is looking years ahead, already making plans for the next battle. This is exactly why I hope it doesn't happen, but if it does, it will show you the type of legal teams we're up against here. Sometimes I think, wow, Ripple might end up being really lucky. Because while the rest of the industry has been waiting for clarification in this matter for years, Ripple may end up getting what it deserves. Ripple has built a top-notch legal team, thus they should win their token definition case. As a precautionary measure to make sure they got a fair ruling. That I do not consider XRP to be a security. Once we wrap up this video, we'll discuss some upcoming events in the cryptocurrency industry that you should be aware of. First and foremost, on March 9th, there will be a Digital Assets Subcommittee hearing. This should be an interesting event, as it will bring together a wide range of CEOs and academics to discuss the pros and cons of digital assets before a congressional panel. Even if we don't learn anything significant from this hearing, at least the conversation has begun. The more of these preliminary hearings we complete, the closer we'll be to having Gary Gensler testify before Congress, which is where I expect things to really heat up. The first official steps toward. On March 7th, a court proceeding involving the companies Grayscale and the Securities and Exchange Commission, SEC, is scheduled to begin. In essence, Grayscale is suing the SEC, and you'll get to hear them say, "It will be interesting to hear the SEC's reasoning for approving a futures ETF while rejecting a spot ETF, given that both types of ETFs are pegged to the same underlying price." It will show how the SEC has been trying to slow the industry for political reasons. I don't think they have a leg to stand on in this case, but it will be interesting to see if they try regardless. This is a major case for the business, so everyone should pay attention. The time you spent here is greatly appreciated. If you like this update, please hit the like button and sign up for more. For the time being, pickle out.